And welcome back to PI's The Break. My name is Clare Irvine. I'm Government Affairs Counsel here at PIA. Today, we have Brad Lachut, our Director of Government and Industry Affairs, here to talk about New York cybersecurity compliance. And before you think you're clicking on a 5-hour video, it's specifically addressing the issues related to the notices DFS has been sending out this summer on non-compliance and to kind of just very high level issues related to that. So without further ado, I'll turn it over to Brad for what will not be a 5-hour course.
Thank you, Claire. Yeah, this is not going to be the infinite jest of breaks. We're going to try to keep this as short as possible and keep it high level. So thank you. As Claire mentioned, the break is on New York cybersecurity compliance with an emphasis on the compliance aspect. Quickly, I'll give you just a rundown of what the regulation is in a nutshell so you know what we're talking about. We are talking about New York cybersecurity regulation 23-2ICRR 500 for those who use those sort of terms, which is probably only me and Claire, honestly. It has been a regulation that's been on the books for about 3 or 4 years now, and I think most New York licensees should be aware of it. And if they're not, please become aware of it. In short, all insurance agents, brokers, companies that are licensed in New York, whether the resident or non-resident, are required to comply with this regulation. The regulation refers to these individuals or these entities as covered entities, and that's the term I'm going to be using throughout. So be aware when I say covered entity, it means you, as long as you're licensed in New York. The regulation has 3 major components to it, or 4 major components to it, and this is a gross oversimplification, just so you know. First, you have to conduct a risk assessment. Second, you need to develop a cybersecurity program, and you need to prepare a written cybersecurity policy. I'm not going to get into any of those things because it's going to take far too much time, and we have other resources, both written and CE courses available that will go into greater depth in there, and I would encourage you to seek those out. The final aspect is a filing with the New York Department of Financial Services, and that is what we're going to be talking about here in a little bit of greater detail. Under the regulation, there are exemptions. So all covered entities are required to comply with this regulation from the onset. However, if you qualify for an exemption, you might have less responsibilities to the point where you might not have any responsibilities at all, although that's going to be a small percentage of people. The vast majority of the exemptions are limited exemptions and not total exemptions. It's very important to note because a limited exemption means you still have to do something. Which a lot of people don't necessarily realize. They hear exemption and think, great, I don't have to do anything for this regulation, and that's not the case. So the most common exemption that an agency will run into is one based on size or revenue. What you're seeing in your screen right now, if you have less than 10 employees, less than 5 million in revenue, or less than 10 million in assets, and this is an or, so even if you have 11 employees but have less than 5 million in revenue, you'd qualify for this limited exemption. You are under this limited exemption and about half the regulation gets thrown out the window. You still have to do about 6 or 7 things, but it's far less than the 15 things that those who don't qualify for the limited exemption must do. A lot of the more onerous and potentially expensive steps are removed for those who qualify for the limited exemption. And a lot of agencies, a lot of covered entities will qualify for the limited exemption, including, I think, almost all non-resident covered entities. The other exemption that comes into play is more of a total exemption, but with a small caveat, and I'll get into that. It's covered entities who are covered by the cybersecurity program of another covered entity, which, i.e. employees of an agency. Employee of an agency presumably has a license. The agency also would have some sort of license, so they would both be covered entities and required to comply with this regulation, although it doesn't make much sense for an employee to have a information or a cybersecurity program for an information system that they don't actually control because the agency controls it. So there is more of a total exemption there. There is still a filing requirement, which I'm going to talk about right now. So under the regulation, all covered entities have some sort of filing requirement at some point. It's just a matter of how much and how frequently you have to file some paperwork with DFS. Any covered entity, that qualifies for an exemption, be it a limited one or the employee one that I mentioned, have to file that they are actually an exempt entity. So if you have under 10 employees or under $5 million in revenue, you would certify to DFS that you qualify for one of those exemptions. There's a section on the DFS website. The link is at the bottom of this video, where you can go and indicate which exemption you would file for. If you're an agency, just go back real quick. 519A1, 519A2, and 519A3 are all there, and you'd want to click all the ones that apply. Generally speaking, it's going to be all three of those for a limited exempt agency. Once you do that, you're all set. You only have to do that one time, usually. Now, when this regulation first came out, DFS required all that qualified for the exemption to file for the exemption and said it was one time only. The following year, they asked everybody to do it again. It seemed to be that was based on a computer system change with DFS, so they required everybody to file their exemption. So if you did not do that again, that could be an issue. That is an issue, and maybe a reason why you have received a non-compliance notice from DFS, because you are required to file that again. Once you file that a second time, hypothetically, you shouldn't have to do it again, but I guess we'll see what comes down the road. That also goes for any entity that is filing under the 519B exemption as an employee. That must be done one time only, again, with that caveat that I just mentioned. The advantage of the 519B exemption is that you don't have any further steps. Once you file that exemption, you're essentially done because you're under the cybersecurity program of another covered entity. Now, those other covered entities, excuse me, the agencies, the limited exemption agencies, must still file another piece of paperwork with DFS. And this applies to all covered entities, limited, exempt, and not, again, with the exception of the employees that I mentioned. That certification says that you are in compliance with the regulation. So it's saying that you've done your risk assessment, you've created your cybersecurity plan and program, and that must be done every year. Usually it's going to be April 15th of every year. This year it was different because of COVID. The deadline was extended. Those filings are for the previous year. So it's like your tax returns. You're filing in 2020 for the 2019 year. Same thing here. You're filing in 2020 for the 2019 cyber year, if you will. And again, that must be done every single year, unlike the limited exemption filing that only needs to be done once. So this is another area where you might fall into some problems. If you only filed your certification of compliance once, thinking that's all you needed to do, you might have received a notice from DFS. You need to do it every year. The other aspect in this is that many producers have multiple licenses, right? They might have an agent and a broker license. They might sell life and health as well as P&C. All those licenses need to be accounted for. It could be that you just need to file your one-time employee exemption for that license and then you're done. It might be that you need to file a certification of compliance for that license every year. It's going to vary depending on the covered entity and how you're using that license and what your employment status is. But be aware that all of those licenses are considered individual, so to speak, under the regulation and need to be accounted for. Just because the one person, John Smith, is filing doesn't mean that every license that is associated with John Smith is also brought in when that one person is filing an exemption or a certification of compliance. It needs to be indicated in the filing. So that's another major area where many covered entities have fallen into this trap of, well, I filed my exemption. Yeah, you did it for your P&C license, but you forgot to do it for your life and health license. So that is going to be a non-compliance issue for DFS and something that should be corrected by the covered entity. Fairly easy correction. You just need to go onto the website and file your exemption, then you should be good. But again, you actually need to proactively go and do that. And again, as long as it's an exemption filing, it only needs to be done once and you can forget about it. So with that, I'm going to conclude. I'll turn it over to you, Claire, if you have any questions. I know that was an incredibly fast review of this regulation. Again, we didn't get into the kind of the nuts and bolts of the actual reg itself. That is for another time. But hopefully this helps in terms of answering some major compliance issues that have come up recently.
Yeah, I think you did a good job hitting kind of the issues that have we've been seeing the last couple months. I will note that I know a lot of people, particularly in the Northeast, have multiple licenses. So you're thinking, do I have to do this in Connecticut or New Hampshire or New Jersey? None of those states, even the ones with cybersecurity legislation, require filing similar to New York. They kind of went in the NIC went in a different direction. So this is a very New York specific thing, whether you live in New York or not, for New York people with New York licenses.
That's a really good point, Claire. Thank you. Yeah, this is very specific to New York, as you said. If you're in another state, you still need to comply with New York, but don't necessarily worry about your own state cybersecurity stuff, at least not yet.
Yeah. Yeah, you might have to comply with the legislation and the laws in your state, but there's not those states haven't had the filing requirement. So it's comply and comply, document compliance, no filing.
Perfect.
So, okay, well, thanks, Brad.
My pleasure, Claire. Thank you so much. Hope everybody found this informative, and we'll see everybody soon. Oh no.